Good morning. Today's video, I'll be talking about two separate subjects. The first one, we will talk about H-2A temporary agricultural workers because we are doing a series of employment-based type of petitions. And the second subject, I'll be talking about unlawful presence and bars of inadmissibility because I've been receiving a lot of questions on those. I'm just going to briefly address that. And at the end, I'll talk about the store that we have on YouTube so that you can check those items out based on the type of thing that you want. And because we are reaching that Christmas mark, and you need to start sharing, right? Gift sharing, that's the season. So my name is Bijou Ngwanda. I'm an immigration lawyer here in DC. I am born in Kentucky and, of course, the District of Columbia as well. I do work complex immigration cases across the country and around the world because we'll deal with consular processing as well. And if you need a consultation with me, you can either call my office 202-751-2180 or please email me if you're outside of the country. But again, consultation fees applies for any type of consultation that you're willing to be doing with me. Having said that, this is a great morning. It's 9:43 a.m. in the East Coast here. Having said that, let me share my screen with you so we can talk a little bit about H-2A temporary agriculture. Remember back, we used to talk about this Farm Workers Modernization Act, where they wanted to give a pathway to citizenship to farm workers, and that hope went dead pretty much. And now we have a Plan C that has really pretty much almost like nothing except for parole and 5 years of work permits and travel document, which can help some of those other people to actually go home. But when I will talk about unlawful presence, then you will see how this thing is going to play out. Let's say if Plan C come to life, right? So let's start with the first subject. Let me share my screen with you. Sharing the screen, just give me one moment here to share the screen. Okay, who may qualify for H-2A classification? Oh, well, so if we go here, it said to qualify for H-2A non-immigrant classification. This is the key word here, non-immigrant, because this type of visa, it's a work visa that is for the duration of 3 years. It can be renewed as well, but it is a non-immigrant type of visa, so it's not permanent, temporary workers, okay? The petitioner must offer a job that is temporary or seasonal nature. So the employer, the person who's hiring you, must offer a job that is temporary or seasonal in nature. That has to do with agriculture, of course. Demonstrate that there are not enough U.S. workers who are able, willing, qualified, and available to do the temporary work. That's when they go to labor certification, right? They have to be able to demonstrate that in order to get that certification, certified from the U.S. Department of Labor, and show that employing H-2A workers will not adversely affect the wages and working conditions of similarly employee U.S. workers. Occasion and generally submit a single valid temporary labor certification from the U.S. Department of Labor with the H-2A petition. Okay, you can see details here. Well, the program process, how does it work? Well, the first thing is the petitioner, that's the process, the way it works, right? The petitioner submits temporary labor certification application to U.S. Department of Labor. And really, this is where it gets really messy because while the petitioner must prove all those things, demonstrate that there are not enough U.S. workers who are able, willing, qualified, and available to do the temporary work, and then show that employing H-2A workers will not adversely affect the wages and working conditions of similarly employed U.S. workers. And remember yesterday, no, maybe I believe on Monday when we were talking about Schedule A designation workers or petitions, we were talking about the fact that the employer, when it comes to Schedule A type of petitions, which is pretty much people with extraordinary abilities and therapists and nurses, the employer, when you have a job offer in that category, for example, Schedule A category, the employer does not have to go through labor certification because the Department of Labor has already pre-qualified, predetermined that there are not enough U.S. workers. So what we do in that case, we pretty much just fill that form without going through the labor certification. We just fill the form itself and attach it to the petition I-140, combined with a green card if possible, and then send it to USCIS. But in this case, it's different. The employer must go through labor certification and prove those two following things. Okay, and then step number 2, petitioner submit the form I-129 to USCIS after receiving the temporary labor certification. And then step 3, a prospective employer also outside of the United States apply for a visa and admission after USCIS approves for I-129. So 3 steps. First, the employer submit the temporary labor certification application to the U.S. Department of Labor. Then the petitioner submit the form I-129 to USCIS, and after it is approved, then the beneficiary goes to consular processing. So, but who is eligible to participate in the program? Not each country. So you have to go here and look at if your country is, when you're requesting your employer to offer you a job, you have to know, first of all, if your country is part of the program. If it's not here, it's not going to work. As simple as that. And then how long the person can stay? Well, the person who has held TOEIC non-immigrant status for at least 2 years must depart and remain outside of the United States for an uninterrupted period of 3 months before seeking readmission. So you come 3 years, you go, you stay at least 3 months and then come back. But initially they don't give you 3 years, right? So, sometimes they give 1 year and then they keep renewing it until 3 years. And then after 3 years, you can go out and come back 3 months later and seek readmission. So that's another way to live in the U.S. Based on temporary jobs. And this is really the most common one. A lot of people in the agriculture sector, they do it because they get visa easily, because a lot of those type of work, a lot of people here, they don't want to do it, or they don't have the ability to do it, like the qualifications. If you qualify as an agriculture or you have certificate, well, you can request really an employer here to petition for you. So pretty much that's what I wanted to talk about. Really, I wanted to talk about another way to live here temporarily, on a temporarily type of visa, work visa. So let's move on to unlawful presence and the bars to admissibility. Well, a lot of people, what I've noticed with my clients, a lot of people here, the reason they cannot adjust status, even though they have approved petitions, it's because of this unlawful presence and the bars to admissibility. And some of those individuals cannot get their waiver to be granted. So, and therefore they're stuck in a situation where, well, they can't really leave now because now they have accrued a lot of unlawful presence, and they can't really adjust status because one of the waiver has never been approved. So we're going to explain a little bit what it is, how it works, and what is the cure, if there's any, right? And the reason really we are talking about it today is in the hope that the Plan C will pass, because this is what's going to happen. If Plan C passes, okay, and people apply for parole, unless the person has other inadmissibility issues, for example, other crimes, felony, etc. But if the only problem is unlawful presence, then what's going to happen is if Plan C passes, well, people are going to apply for parole, and parole simply means permission to stay in the U.S. legally. At that point, everybody who has unlawful presence becomes legal, right? The presence becomes legal, just like DACA recipients and temporary protected status holders. So your presence becomes legal. And let's say that you had an approved petition before, or you have a child who's going to turn 21 to petition for you and find you in that lawful status. Then by the time that approval come to play, you can in fact adjust status because now you become lawfully present. You see? So that's why we really want this Plan C to work, because it's going to save a lot of people in those situations. So unlawful presence, what does it say? Unlawful presence is the period of time when you are in the United States without being admitted or paroled, or when you are not in a period of stay authorized by secretary. You may be barred from being admitted to the United States. For example, let's say somebody who comes with a B1 visa, visitor, remember, even if they give you 10 years, 2 years, well, you have to stay here for within 6 months or less, really, then get out, then come back, especially if you have multiple entry. The moment you stay longer than 6 months, you have accrued unlawful presence. So now what is going to happen? You'll be barred for 3 years. If you depart the United States after having accrued more than 180 days, but less than 1 year of unlawful presence during a single stay and before removal proceedings begins. Okay? 10 years if you depart the United States after accrued 1 year or more of unlawful presence during a single stay, regardless of whether you leave before, during, or after removal proceedings. Okay? Let me explain. You come with a visitor visa, you stay here for more than 180 days, which is 6 months, but less than 1 year. Then you go home, and now you find yourself that you want to come back and go to apply for a visa to come back. Well, you're not, because now you have a bar of 3 years, unless a waiver applies in your condition. 10 years is if you stay for longer than 1 year. Okay, then whether you leave before, during, or after removal proceedings, it doesn't matter. The bar is 10 years. Permanently, if you re-enter and try to re-enter the United States without being admitted or paroled after having accrued more than 1 year in aggregate during one or more stays in the United States. Okay, so basically you come to the United States and then you stay, you come again, you stay, you come again, you stay, or maybe they didn't catch you, but in aggregate 1 year of unlawful presence. Now you attempt to enter illegally without being enter without inspection. So while you will be barred from permanently if you leave again. Okay, so that's how it works. And what is the basically the cure? Well, we have this one. We have the form waivers, right? I-192, application for advance permission to enter as non-immigrant, application for waiver of grant of inadmissibility. This one you can apply for it within the outside or inside of the US. 601A, you can only apply for this one inside of the US, and this one, once it is actually approved, then you leave and ask for consular processing, and then come back. But you have to meet the requirement in order to apply for those, especially 601, 601A. Well, you have to have a qualifying relative, right? Qualifying relative, child, spouse, parent of a U.S. citizen or lawful permanent resident. At that point, you can apply for those waivers, and hopefully you get it, and then you can adjust status. That's how it works. So that's really pretty much like a summary of it, right? But you can go here and read it for yourself and see really what it says when it comes to unlawful presence. But the reason I wanted to point it out today is because we are still hoping that Plan C will work. My friend, if this Plan C works, a lot of people, I've talked to a lot of clients. For example, I have one where the I-130 was approved by his father, but the client cannot adjust status because unlawfully present. By the time they're adjusting status, they're not into a lawful status. Asylum case was pending still with USCIS, but that's not lawful presence at the time you are adjusting status. So they couldn't adjust status. So waiver didn't work out. Well, they never tried, but according to them, they tried, but it never worked out. So, but now, if this Plan C happened, and they happen to be here before 2011, which they are, so this is it's gonna, when they apply for parole, they are going to be lawfully present once parole is approved. At that point, they can go back with their approved I-130 petition and file another form I-485 and adjust status in the U.S. You see how this is going to play out? So that's why some people say, well, Plan C is not bad. It's bad. Not a lot of people will be included. Of course, not a lot of people will be included, but some people will be included. If we're talking about 6 million of individual, well, I know it's not enough compared to 11 millions, but at least we will see some individual adjusting their status. So, but when is it going to happen? We don't know, because we don't know if this Senator Manchin will align himself with his own party. So that's the problem here, right? And if they're going to make it happen by the end or before Christmas, by the end of this year, we don't know. And with this border crisis that keep we don't know. And then the Biden administration, they lost their bid to get the U.S. Supreme Court to revisit their decision. They lost it to stop the Humane in Mexico policy. So even the Supreme Court do not agree with this Biden administration, because they came about and they reinstore MPP back, the Trump administration program. So we have a lot of issues going on, which pretty much undermining this Plan C. So how this is going to play out, my friend, I don't know. But we hope for the best, as usual, right? My friend, there's no other alternative. We'll always hope for the best. So stop sharing here. Back here. Wow, that was a long live recording. I talked about 2 different topics. Could be related, could be unrelated, but it's all about immigration. Please go ahead and share, like. Don't forget to comment below. If you need a consultation, again, 202-751-2180. Consultation fees apply, my friend. So until next time, bye-bye.